The caregiver agreement is the legal shield you need. Let's talk about it. Last year, a family had a verbal agreement to use their father's retirement funds to pay their brother to provide around-the-clock care for their dad. Once the funds were spent, the family applied for Medicaid benefits. However, because the family had no caregiver agreement, the state was concerned that the money was a gift to the son. This creates a huge risk for their father's ability to qualify for Medicaid. If the family cannot prove that those payments were a legitimate expense for care, their father could be locked out of Medicaid benefits for a long time. So if you're sitting there thinking a handshake deal to pay my daughter or grandson for helping your mom, it's just keeping it in the family, you need to listen closely. That informal approach, that one piece of paper that's missing can turn genuine love and loyalty into an absolute financial catastrophe. I've seen it happen. This isn't just about money. It's about peace of mind, family harmony, and protecting what you've worked for. It's easy to feel like Medicaid's being cruel or nitpicky. I have many people comment about that, but it's not personal. It's a giant impersonal math equation. In most states, if a single applicant has more than $2,000 in countable assets, they're out of luck. They will not qualify to get help with those sky-high nursing homes or assisted living bills. To prevent people from just shoveling money out the door the day before they apply for Medicaid, Medicaid implemented what's called the look-back period. They scrutinize your financial records for 5 full years prior to your application, searching for any transfer that wasn't for fair market value. Think of it this way. If you write a check to your child based on a verbal promise, Medicaid can see that as a gift. And that's where the math comes in. They take that gift, the total amount, and divide it by the average daily cost of care in your state. That's the number of days the applicant is barred from coverage. It's called the penalty period. So if a family paid their brother $6,000 a month for 12 months, that's a total of $72,000. If the state caseworker determines it's a gift, they would divide $72,000 by your state's average cost of care for 1 month. For this example, let's say that the average cost is $12,000 for the month. The penalty then would be almost 6 full months. Most families facing that kind of a bill would end up in a world of hurt. It's a brutal reality, but it's the system we're navigating. Families get tripped up because they tell themselves 3 myths that are rooted in the idea that we're family. Myth 1, it's just family. Helping family, we don't need paperwork. That's not true. Medicaid doesn't care about your intentions, only documentation. If there's no signed, detailed, and dated agreement in place before payments begin, the money can be seen as a gift, period. Myth 2, we kept a detailed notebook of our hours on a handwritten logbook. Well, that's great, but a logbook is not what Medicaid wants. They want to see a contract signed and sealed before the first dollar changes hands. Myth number 3, we wrote caregiving in the check memo, so we're safe. This is not true. If you put like in-home care on your Venmo or your Zelle payment, thinking that you're being clear, those are meaningless memos to Medicaid. The state wants a formal, comprehensive caregiver agreement. So what should the anatomy of a Medicaid-compliant caregiver agreement look like? Think of a Medicaid-compliant caregiver agreement as a business contract for care. It's a legally binding document that transforms informal family payments into legitimate documented expenses that Medicaid will recognize. Here's what it absolutely needs to have. First, it needs to be signed and dated before the services begin. This is non-negotiable. It proves the agreement was in place from the start, not as a retroactive fix. Second, it needs to state the exact tasks to be performed. We're talking specifics: bathing, medication management, grocery shopping, transportation, laundry, meal preparation. You can't just write caregiving. This documentation shows Medicaid the scope of the services that are being paid for. Third, it must list the hourly rate. It can't be an arbitrary number. It has to be a reasonable rate based on what local home health agencies charge for similar services. This ensures the pay is consistent with market rates, which is critical. It has to be seen as a legitimate expense and not a disguised gift. Fourth, it should show the weekly maximum hours or compensation. This demonstrates a structured arrangement, not an open-ended family payout. And fifth, it must require the caregiver to keep a log or a timesheet. These detailed logs create a proof and substantiates the payments that are under the contract. Any changes, like a pay raise, require written amendment to the original agreement. And the pay has to be reported as taxable income. Many states require notarization or at least 2 interested witnesses to document it, to add another layer of validity. These elements are important in the eyes of a Medicaid caseworker. When paying a family member for care with a caregiver agreement, it's a legitimate spend down of assets. It's the same love, the same caregiver, and the same cash flow, but a totally acceptable way with Medicaid. Now, all because of one critical document, it will replace that handshake deal with a strategic compliant plan. Even with the best of intentions, families often stumble when drafting these agreements. So let's talk a little bit about drafting the agreements and trying to avoid some pitfalls. First, you can't name more than one caregiver in the same contract. That's a red flag. If a daughter and a son are splitting the duties, you need 2 separate contracts. Each caregiver must have their own distinct agreement outlining their specific responsibilities and pay. Second, forgetting a termination clause. Believe it or not, Medicaid really wants to see that the agreement can end. It protects both parties if the circumstances change and shows that the contract is a professional agreement, not just a permanent unconditional payout. Third, setting the rate at 0. Family might just want to formalize the chores but not the pay. Well, that seems harmless. A $0 contract doesn't help you spend down assets for Medicaid eligibility. Compensation must be present, reasonable, and actually paid. Fourth, backdating is a huge no-no and can be viewed as fraud. Any attempt to make an agreement look like it was signed earlier than it actually was will be spotted. And fifth, ignoring the state quirks. While one state may require a physician's letter justifying the need for the care, another state might want the hourly rate to be within a specific percentage of the regional average. So how should you get started? Are you feeling overwhelmed? Don't be. Take action now. Start doing these things. Step 1, add up the care hours realistically. Don't guess. For 2 weeks, keep a detailed diary of every caregiving task and the time it takes. This gives you a solid, data-driven baseline for the hours in your agreement. Step 2, call 3 local home health agencies and get quotes for their hourly rates. Print them out. Keep them as documents for your evidence. You want your rate to be a reasonable market rate for compensation. Medicaid will accept that. And then step 3, download our sample caregiver agreement that we have linked in the description. I recommend you meet with a Medicaid elder law attorney to review all your legal documents. Step 4, don't pay the caregiver in cash. You want a clean, transparent paper trail for every transaction. It makes documentation simple, which Medicaid loves. Step 5, every single week, have the caregiver fill out and sign a timesheet. This creates the records that you need to prove that the services were performed. Do these things and you will have a robust paper wall between you and your family's future and the Medicaid look-back bulldozer. So if you're watching this and thinking, oh no, my brother already moved in with my mom and we're definitely been winging it, don't panic. While it's always best to have the agreement in place before care begins, get one signed as soon as possible and document all the previous payments. The takeaway here is crucial. Get this agreement signed as soon as possible. When it comes to family, let's be honest, mixing money and caregiving is a recipe for family tension. A formal caregiver agreement isn't just for Medicaid, it's a tool for your family peace. A contract sets clear expectations for everyone. The caregiver knows exactly what the job entails and what it pays, which prevents feelings of being taken advantage of or taken for granted. Now, for a quick but vital dose of tax reality, if you're the caregiver receiving payments, you'll need to report that as income. There's no getting around it. For the care recipient, they may be able to claim a medical care dependency deduction if they itemize, and that can be a helpful tax break. So there's a critical point in which if the family member earns more than the IRS threshold for a given year, then they likely have to pay payroll taxes, even if it's your own daughter or son. Many families overlook this and could get a nasty surprise from the IRS. So check with a certified public accountant. Medicaid isn't trying to be a villain and steal your house or benefits or make things difficult. You don't want an informal handshake. Create a properly drafted caregiver agreement and sign it before care begins. That's your family's most powerful tool. And it transforms every dollar paid into a Medicaid compliant expense. So get it done right. If this information was a wake-up call, please subscribe. I'll see you soon.